going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys have had a great day so far. Happy Thursday. Almost finished with the week. Unfortunately, summer's almost over too. Got a big holiday weekend coming up. Hopefully you guys are safe. You guys know the routine. Don't do anything dumb. I will cover you. I will cover your court case if you do something dumb. All right. Hope you guys are having a great time or a great day. Great time. We just started. I hope you guys have a great time. All right. I need to stop rambling. How am I mixing up words already? All right, let's just go. I got all Judge Simpson except for the very last case. I've got an interesting one from Judge Middleton today, but this is all today. All Judge Simpson until the end. Just went through and picked out my favorite ones from his docket today. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Nobody's there. Court does call the case of the people versus Aaron Hawkins.
Sinatra for the people.
Okay, this is perfect because this defendant is named Aaron. Aaron, you done messed up, Aaron. I was gonna save that for later, but you had to say it first.
Hawkins.
What's these people on? Why is he repeating what I say?
Aspirations.
Oh, wow.
All right, I feel like I have to say this because I don't know how many people know this. Already 2 pauses in the first 2 minutes. I know I got to get better at this, but Torchio Feaster ran for judge a couple years ago. When I was looking I was trying to find an email or a phone number so I could, ask him for an interview. And I found a bunch of articles on him running for judge. So, aspirations on, repeating what Judge Simpson was saying. Yeah, he didn't win. So I think that. Look at the face on Judge Simpson right now. Okay, now let's go.
Okay. This is Public Defender Jay Bones on behalf of Mr. Hawkins, who appears to my right. Your Honor, Mr. Hawkins, can you please state your name for the record?
Aaron Hawkins. Thank you, sir. All right.
Your Honor, it's my understanding that we're to be asking for a 3-week adjournment on this matter so that we can continue a referral for drug treatment court. Is that what you're being referred to? This is this Pater case. It's not here today. I understand that there's a bond violation in this matter as well. We have discussed that, Your Honor. My client is willing to admit to the violation, Your Honor. He would be asking for a scram tether. He's asking release so that he can continue working. He works for a trucking company. He's not a driver for a trucking company, however, but he would like to maintain his employment. He advises that if he is today that he's going to lose his job. He's hopeful for a scram tether so that we can keep track of him that way in terms of any future allegations, which he submits that he won't have any.
I don't know if there's anything from the people.
And what was the nature of the bond?
On October 26, 2024, at 12 a.m., he blew a .055, then continued to blow numbers throughout the morning through the 26th and admitted to consuming alcohol.
Right, I would just let the court know, and this might be in the bond information.
No, I never worked with chili. I mean, well, technically I did. When I worked at a restaurant, I made chili every day. We had really good chili, and I made that. So technically I worked with chili, but no, Chili de Castro. I did not work with him. I did go undercover and try to get to know him personally. You know, when all the stuff was going on, yeah, I pretended to have a fight with Irish Demon so I could jump into Chili's chat and get to know him, and I did, and I got to know him personally, and that's why I stopped doing it. It just wasn't worth it. I wasn't having fun doing it, and I didn't like it. But no, I didn't work with him. No.
One of his priors is a high BAC.
Yes.
19. This present case, the alcohol level was a 0.17.
Yeah, that is, Your Honor, we would respond briefly by stating that that is why he's trying to get into the sobriety court. He recognizes that he has an issue and he's asking for leniency and getting a scram tether so that he can be better monitored. He did ask for that at arraignment. He wasn't given that, however, but recognizes that there is an issue.
What are you asking me to do with the case?
Adjourn the matter for 3 weeks so we can continue the referral.
Tell you what, I'm gonna adjourn it out 1 week to September 5th, 2024, 9 a.m. But at this time, until he's got something in place, he isn't even gonna have anything in place, does it?
He does have the
The what?
portable, Your Honor.
Yeah, that didn't do any good.
I understood.
I mean, I'm talking in terms of any treatment, anything. What's he doing in terms of any treatment?
I'm sorry.
What's he doing in terms of trying to get himself into treatment?
I speak. That's what I was waiting for. I was waiting for the attorney to let me know what I was supposed to do next. That's
In terms of the referral for drug treatment court, Your Honor, with Judge Nucky.
Right, but you can get yourself into treatment.
Have you done anything?
You're
in that
you're
regard?
now here on your second drunk driving. First one was, from my understanding, a high BAC.
Correct.
You don't even make it through a couple of weeks in terms of a bond condition of being on the sober link before you're blowing numbers, and you're not blowing them at a low rate.
You done messed up, AA Ron. I had to get it in. I had to get it in.
If you didn't have an attorney, you still have a problem and you need to deal with that. So don't try to blame somebody else that I'm waiting on something. I'll put his probable cause hearing out to the 5th. So I'll give a 1 week adjournment, but at this time, defendant's bond is revoked, defendant's remanded.
Thank you.
Court does call the case of People versus Matthew Havens.
All right. I didn't put we actually got two back to back. I could have actually probably played an hour of his docket straight through today. So much happened in Judge Simpson's court today. Funny, kind of sad. I don't know. I don't know what to call it when someone gets arrested because I don't think it's funny at all. But so it's not really sad either. I don't know what I would call it. I don't want to say entertaining, but even though we watch it, it's not a good word to use in this situation. All right, I'm just going to keep playing the video.
Paste it.
Ready, Judge.
And I'm a moron. Apparently, I just let it play too long. All right, I'm not going to pause it.
Good. Give me a good phone number for you.
It's 248-509-08.
First assistant Sorry, Judge. I was really in shock, and that was just my
I
first.
know you were shocked to see him. I wasn't even in there.
First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Durant. Go ahead and state your name, sir.
Omar Durant.
Thank you, sir. All right, what are we doing?
Your Honor, I just got a good phone number from him. I'm gonna ask
I know,
him to
we all
chat.
heard.
I'm sorry.
So you needed nothing. You needed adjournment?
Yes, please.
Probable cause conference, September 12th, 2024, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
Make sure to get in touch with them. Okay, sir. Thank you. Court calls case People versus Jonathan Lilly.
Deborah Schloss on behalf of the defendant, Mr. Lilly, who is approaching.
Your name, sir?
Jonathan Lilly.
Thank you. What are we doing?
So, Your Honor, my client had a no bond. He had a warrant for his arrest. We had him arraigned. You set no bond.
I did.
And Your Honor, I'm asking you to consider changing that. The reason you set a no bond is that he did not test for a number of days. And the reason for that, it was a complete misunderstanding on his part. And as soon as he spoke with me about it, he tried to correct the situation. He believed that once he was on the supervision of community corrections or pretrial services, that he did not have to test any further. He was
Excuse me? Say that again.
Basically, the whole situation is when I signed that blue form, nobody explained to me what the form meant. So I took an assumption of thinking that I didn't have to do that and I was going to get parole.
No.
Yeah.
July 9th, he tested positive for THC. July 10th, tested negative on an ETG and PBT. The 15th of July, he tested again and was positive. On the 17th of July, negative, tested, 23rd, negative. But all those points he takes test. Starting in August, he just doesn't test.
Right, and that's, Your Honor, because he misunderstood. It's in terms of the positive, but
What changed in August?
It was just the simple fact that I thought that form meant I did not have to come in. Yes, it was my fault. I should have asked.
What
more
form?
questions. It's a blue form that basically is stating, I thought they was going to give me a parole agent and they asked if I was going through any.
All right. I didn't understand why people kept saying Jude Simpson, or they were saying Jude. I was like, I don't know. Is this a joke? I didn't know where this was coming from. Oh, it was a typo. I fixed it. The title of the video said Jude Simpson. There was a long-standing joke about who is Judge Simpson, as he knew. I said that in one video, and I got a bunch of comments saying who he was. Like, no, it was a joke. I know he's not new. So I thought that was what you guys were doing. No, Jude Simpson. All right, I get it now. My bad.
Type of care, through any agency for the drug testing.
And Your Honor, for the record,
That makes no sense.
For the record, Your Honor, we had not discussed this. The minute that I learned that this was going on, I did contact Mr. Lilly. He really did believe that, despite the
That's why I turned myself in.
And Your Honor, I told him, I want you to come to court, to the testing facility and test immediately. So he went the next morning.
Today on this case?
So, Your Honor, I am asking, and I just want to explain the THC also. He had smoked pot before he was arraigned, so it was still in his system. It's not any new usage, and the levels went down. I am asking that you.
Well, we don't know if the levels always went down, because at some point he stopped testing. And I would know that his last test may have been masking because I have abnormal creatinine.
Your Honor, he will test going forward. He's had a very tough lesson of being not on his job for a whole week. He's in danger of losing his job until that you lost your job. All right, and until that point, he was doing everything the court ordered. I really do believe, as much as you doubt it, Your Honor, that he really did believe he did not have to test when he was coming in regularly and doing everything he was supposed to do. So I'm asking, Your Honor, that you release him and he'll be testing.
He has one like that? Wow.
You said it last week.
Oh, okay.
Your Honor, he will be testing and he will not miss a single test. And he will not have a positive test. And I am asking you, he's been in the jail for over a week. And I'm asking you, Your Honor, to please reinstate bond he will do everything. I know it sounds doubtful, but he really did believe he didn't have to. He didn't do this intentionally. When I called him, he was shocked that he was still supposed to do this. So he legitimately did think he didn't have to.
I'm still trying to figure out what made him stop.
Your Honor, it was simply that misunderstanding of the form. It wasn't because I felt like I couldn't do it or that, you know what I'm saying, that the test that went wrong, I simply was doing everything to a T, Your Honor.
And Your Honor, when I told him.
All right, so this is his defense. I signed this form. It's blue. I don't know why that was important, but he remembered that detail. I signed this blue form. I don't know what I just signed, so I just stopped doing everything. I'm waiting. Really?
You have to immediately go in and test. He did. And they were just going to test him and let him go. He himself told them, I have a warrant for my arrest. He was very open and honest with them. He could have ended up coming in here that day and had this hearing. Instead, he was honest. They arrested him. He couldn't come in that day. It was too late.
If I reinstate his testing, will you stop?
Yes.
Anything from the people?
The people would like to be heard. When the defendant was arraigned, we actually asked for $150,000 surety bond. He was granted a PR bond.
When was this? The initial arraignment?
The initial arraignment. He was given a PR bond with testing, frankly, a gift. Obviously, he was unable to comply with that. But $150,000 was the request of our office. And the reason was this involved the defendant traveling under the influence of marijuana in excess of 100 miles an hour, broadsiding an innocent motorist in the city of Ypsilanti and killing that individual. So the defendant's claim that he's struggling with work is a far cry from the woman who was minding her business, driving and was killed. I think that $150,000 surety bond is a much more appropriate bond in this case, given the facts and the charges, than a PR bond with testing, which the defendant wasn't even able to comply with.
Your Honor, he showed up to every court date. He did everything he was supposed to do until this misunderstanding. He will do everything. He had no criminal record, has no criminal record to date. We dispute.
You're saying he turned himself in?
Yes, sir.
Yes.
At the corrections, I also took.
Well, no. So you didn't actually show up at the jail turning yourself in. You went to community corrections to resume your testing that you just unilaterally stopped.
Yes, sir. I said on the whim that she told me to take that as well.
And Your Honor, they were going to let him go and show up to court that afternoon, but he told them, I have a warrant. So they arrested him. So he was being open and honest. It's not like he was trying to abscond. Right after I told them about this.
I'm going to continue as bonded, no bond. I mean, I don't, unless you show me something else regarding that form, regarding that as to why he stopped, because he just stopped. And there's no reason. And in particular, given the nature of the case.
Your Honor, he had a good job. He was working. He would like to resume that.
What do you want me to do with the case?
Well, I would like to set it for another hearing, but I would hope that you would reconsider the no bond.
Yeah.
Can we have it, then can we set another court date, Your Honor?
Yes. What, the 5th? Well, actually, he's already set for the.
Okay, thank you, Your Honor.
All right. Yeah. You guys singing. Yeah, that was an honest mistake. That wasn't an intentional misspelling. I can only use that excuse, once every couple months, Jedi. Sooner or later, people are just going to realize that I just type too fast and I don't really proofread. Kind of like my editing. I kind of suck at editing. I don't like going back and double checking my work. So yeah, it happens. All right. We're still in Judge Simpson. I think this next one is my favorite clip from today, though.
Jail's done.
Yes. I only have one recall.
Who is that?
Mr. Aaron Conversky.
Is that Colin's case?
Yes, sir.
Clerk calls the case, People versus Walter LaCroix. LaCroix? LaCroix? You take it any way you want.
Ready, Judge.
Yeah, Jonathan, I'm on behalf of the people.
Portia Feaster, Assistant Public Defender, Penman, Mr. Walter LaCroix. Mr. LaCroix, please state your name for the record.
Walter LaCroix.
Thank you, Judge. I have spoken to Mr. Emmons about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC. And then I need to address his, it's not a bond violation yet, I don't believe, but it's a bond report where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was.
Well, hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't.
From August 28th?
I don't believe that's the date. Let me check.
Mr. Allen?
Mr. Allen, Sparkle Poots, I am so sorry. The whole Judge Simpson thing came up, and I completely forgot to shout you out about this. That's how easily I get distracted. I'm so sorry, Sparkle. But Sparkle Poots, thank you so much for the 5 gifted memberships, and welcome to the 5 new members. Sparkle Poots, you were awesome. Again, I'm so sorry that took so long to call you out on that. Oh, I feel bad, Sparkle. I really do.
Mine dated August 28th.
In terms of his testing, I have so he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right, and on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th.
So then he got tested on the 16th he was ordered. He wanted to test there. He tests on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then, on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows him.
He tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet,
I was
Judge.
informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community corrections would require, he has signed up again today to test here. and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth. To do that testing, if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Okay.
So let me get this right. He's charged, I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with. He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray.
And then you just smoked it.
I threw it away.
You threw it away? How's that work? Where do you throw it? It's gonna be a long conversation. Where do you throw it away?
There was a little bit left. I used
I
it.
know.
And I disposed of the tray.
You what?
I used it. And I
Oh, you
disposed of the
used
tray.
it then. Okay, so it didn't stay on the tray.
Right.
And I disposed of the tray.
Yeah. Yeah.
I don't want to know how he disposed of the tray. Something tells me he. Never mind. Not making that joke. Not doing it. Guys can't force me to.
Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he's coming today. Yeah?
I'm printing them now.
You're printing them? Mm. I haven't touched that since. So somebody needs to answer for me, why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I don't
have my theory, Your Honor.
Yeah, I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how.
Oh, really? Hold on. You know what? The thing I hate more than anything is when somebody lies to me.
Okay.
Honestly, I'm not.
Okay. Well, just make sure that you because it has to be in your system in order for you to test positive. And if it's been fine.
Counsel, approach briefly. You want to see this? That's my copy, though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive, 22nd to 7 days later.
Yeah. 7 days later. And a little bit he threw away. Okay. Go ahead, I'm sorry. I'm messing up your story.
Oh, I know. Okay. But all I've done is I've used it in the chair that I saw. I've used it. That was it. When it's second, well, no, I didn't know. Okay. Well, we'll tell them that, but you know, medically. I know. I want to do this. I want the truth. Okay.
To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge.
And so that we know.
Thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
sure.
Clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to fix that problem when he's testing there. He is working and he did voluntarily come here today and take a test. So he's asking you to not say that.
No.
No, you have to stay.
All right, anything else?
All I can say, Your Honor. What me say?
Yeah, no, you're absolutely right. And I think a lot of people, especially the people in the chat, already forgot what he's charged with. He's charged with causing death in a motor accident while being high on cocaine. So, yeah, and then he's still doing it while out on bond. His bond must have been high to get out on that. But yeah, this isn't good. This is not good. You're absolutely right, Toby.
You can tell you the truth, okay? My cousin doesn't allow anything.
Yeah, you know, put it in your food and drink.
It's possible. I have friends at my mother's house, but cousin's house to do work down there. Okay. Because I'm gonna eventually reside down at my cousin's house.
All right. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
first one or this one?
The first positive test. Your Honor.
Oh,
The explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Because he can't follow the court's order. I don't know how he's gonna do treatment. And the other thing is, he doesn't test when he's supposed to test.
Yes, Judge.
So it seems to me I have two options. I can let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
9/12?
9/12.
Thank you, Judge.
You're welcome.
Yeah, he's going to jail. I think we all knew that. We saw that coming. Vic, thank you so much for the 5 gifted memberships. I really appreciate it. And welcome to the 5 new members. Thank you so much, Vic. That is awesome. That is awesome. All right, next we have a Psalm sit. This is Judge Simpson says that I think it's her 5th time in front of him. Every time she's in front of him, it's only for about 3 or 4 minutes. So I have to put this in a video, like, a live video where there's, where I can do that. Because I can't just put this out by itself. They're too short. But here we go. Psalm sit. Let's go.
Thank you, Judge.
You're welcome. Court does call the case. People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024 will grant me my freedom on bond. has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community, and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of intent resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
Yep, that just happened. That just happened. All right. Well, we're going to stay in Judge Simpson's court for a little bit longer. Hope you guys don't mind. Let's go.
Let's call the case. The people state of Michigan versus Ali Abakur.
Good afternoon again, Your Honor. Hassan Mahdi on behalf of Ali Abakur is approaching. State your name for the record, please.
Ali Abakur.
All right.
Your Honor, well, at this time, we're going to be asking for a preliminary examination.
Okay, I will be more than happy to set a preliminary examination. Also, counsel, did you?
I did.
The modification of the bond, deal with that.
Your Honor, I did.
Oh, you saw it, okay. Would everybody be ready on the 10th? Or you would?
May I check my calendar, Judge?
Sure.
Yes, Your Honor.
That'll work. Preliminary examination be in person. September 10th, 2024, 9 a.m. before Judge Burke.
Is that time going to change or that?
No, that time is firm, that 9 a.m. time.
Thank you, Your Honor.
As to bond.
Your Honor, I laid it out, I think, pretty clearly in the motion. At this point, we are requesting an increase in the defendant's bond based on his non-compliance with surrendering the weapons. I have had conversations with defense counsel between yesterday and today He has assured me that there is no AR-15 in his possession or otherwise. However, there are other registered weapons to the defendant which have yet to be surrendered. We are in the process of facilitating to have those be surrendered. However, they have not yet been surrendered.
If I may, Your Honor.
Yeah, well, I just want to clarify one thing. He wasn't on the Wayne County matter. He was not arraigned
When the offense occurred.
when this offense occurred.
Correct. It went Wayne County case, the conduct.
Okay.
Washtenaw County case conduct, Wayne County case arraignment, Washtenaw County case arraignment.
Allegedly. Conduct allegedly.
Understood.
Thank you.
But I guess what I was trying to figure out, so the magistrate in setting the bond, you believe, took into account the Wayne County conditions.
I am not certain of that, Your Honor. I was not the one who handled that arraignment or wrote the bond. So I cannot attest to what was said on the record.
I can speak to that.
Go ahead.
So this court knows Wayne County not only put him on a tether, but also home confinement. And Wayne County, obviously, through all their cases, when somebody's charged with a felony, he's not in possession of any firearms, which at that point, Mr. Abukuder was not in possession, and to this day has never been in possession of any firearms after the bond. Now, that being said, I take full accountability for, and when I say I'm saying counsel, for him not turning in those guns or gun or whatever's at the home that we said to the prosecutor they're at. But he is nowhere near that home. He has to be confined to his mother's house, which he's been since day one, since he's left. What I could tell the court is we had many issues with both Washington and Wayne. Why? He has two tethers on his ankles, one on each ankle. And Washington was not going to release him because they were concerned that a tether was going to be cut off, which inevitably, after Wayne County promised they wouldn't cut it off, ended up cutting it off.
Cutting off
the Washington County tether.
Who did?
The Wayne County Sheriff's Department. So, but then they fixed the tether, and then eventually a day later, they released him with two tethers. So it was a big mess. We were trying to get him out. I had discussed with my client this rifle that was, and I believe a lethality or one of the reports that the allegation that the victim said. He said he's not aware of that. He doesn't have that. I left it at that. It's my fault. Registered guns should have been turned over 24 hours after release. He didn't do that. We are not willing. We are going to do that. I've sent the email to the prosecutor, an email stating this is the address that they're at. If you want, Ann Arbor Police Department can come pick them up. We have no issues. We're at the court's mercy. We apologize. I know I'm talking too much, but I want you to know, Judge, it was very difficult getting him out. He definitely doesn't want to go back in. We agree he should have turned in the guns. I'm taking accountability. The guns will be turned over, or guns turned over to the Ann Arbor Police Department. Your Honor, he has not stepped foot outside of that home, other than today, actually, after he was released.
Where are the weapons?
At his sister's house in Detroit. He's confined to his mother's home in Dearborn. And another issue that this court should be aware of.
Hold it. So I thought he lived in Redford.
He lives in Detroit, which is next to Redford, correct?
Correct.
Okay, so it's actually,
I know that.
Well, no, I mean, it has a Detroit zip code.
Redford leases it to Detroit.
Okay, whatever. Redford.
Megan, thank you so much for the raid, my friend. I appreciate it. Welcome to all the Big N Raiders. You went late tonight. I'm sure you just said raid and you dipped out quick. You're like, I'm hungry. It is dinner time for me. Good to see you, bud. I can't wait to go finish your video. I left when the plane, the airplane, the drunk lady in the airplane, that's when I left. So I can't wait to go back and finish that later tonight. But thank you all for rating. I appreciate it. Okay, let's go.
leases it to Detroit. But anyway, so yes, it's Detroit address. 2 blocks away from that address, which currently the alleged victim actually stays at, his home in Detroit. 2 blocks away from that is his sister's home, right? He's nowhere near any of that, and he's all the way in Dearborn with his mother, where he's been since he's left the Wayne County Jail. And he's confined to that home. Now, I don't want to give you my opinion.
But hold on, I'm trying to figure out, why are the weapons at his sister's house?
Well, I can approach on that end. I don't want to say it on the record, but they were not taken to his sister's house during the Wayne County or Washtenaw County's, the Washtenaw County case. They were not taken. They're there, Judge. That's
okay.
They were there prior.
How many weapons are we talking?
1 or 2?
Two. Is that what you have when it comes back that there are 2 weapons? I mean, I realize there's the AR.
The
but-
information from Detective DeMille at Ann Arbor is that he has 2 registered pistols to him. He also noted that the victim noted to Ann Arbor police that he either had access to an AR-15 or had an AR-15 in his possession. Detective DeMille noted that you do not legally have to or required to register an AR-15. So the fact that it is not registered does not mean that he does not have one.
Your Honor, may I approach briefly?
Yes, you may.
Thank you.
I mean, well, before you do, so here's what I'm trying to figure out. There's that, certainly there's that condition. There may have been delays in getting him out and all those other things. I'm trying to figure out, as we speak right now, why those weapons are not in the possession of AAPD. I mean, that's what I'm trying to figure out. And I appreciate you, counsel, taking responsibility for it. But certainly the sister, if that's where they are, could have gotten those weapons and turned them over to AAPD.
She could have. But I know where I guess I know where the court is going with this.
Oh, maybe, because I can change directions in a minute.
No, I get it. And they should have been. I don't know what to tell the court. They should have been turned over.
I sure hope not. I sure hope not. Is my volume really low? I have no idea. Judge Fleischer is blowing me up. Yes. All right. Sorry. Hopefully you guys can hear me.
The reality is it was a mishap, not just on, I don't want to blame him alone. It was on my end. We were more concerned about getting him out.
I understand what counsel's concern is in getting him out.
Yeah.
But the defendant knows he's not supposed to be, particularly given the nature of the charges, he's not supposed to be possessing any firearms.
Which he didn't.
Right. But he was also to turn those over. And I'm trying to figure out between the time of arraignment and as we sit here today, particularly given the fact that they're at this 3rd location, why Ann Arbor PD doesn't have those weapons now.
Now you're correct. They should have been. But what I want to indicate to her, this 3rd location, they've been at that location before he was arraigned, before the Wayne County arraignment. That's my point.
Okay. Sorry. My point is this.
They should.
At some point, counsel gets the motion. At some point,
yesterday,
you two are having some conversation. I'm trying to figure out, particularly if his liberty is in jeopardy, why I don't have those guns now.
Oh, I got the motion yesterday. I wasn't even aware of this. Honestly, just kind of slipped our mind about these guns, the bond that Magistrate Fink had put about the guns being turned over. My point is, as soon as Sister Counsel sent me the email, I called her, I sent her a follow-up email, talked to my client, actually sent her a follow-up email and told her, here's where the guns are. Can you have Ann Arbor Police Department go pick them up? And that was the last that we conversed about that.
That is all correct, but I will say I am concerned because counsel even noted on the record earlier that Wayne County also orders as a standard condition in all of their cases, no firearms.
No,
So that would be 2 cases where he's not in compliance.
Well, I don't want to put words in my mouth. I did not say Wayne County does the same thing by saying you cannot be in possession of any firearms. Magistrate Fink actually went a step further and said you have to turn them over to Ann Arbor Police Department. Wayne County did not do that and did not ask for that, just for the record. And at that point, I didn't know he had any firearms anyway.
Okay. I want the guns.
Yeah, I don't know if they've moved the table back. It still looks the same to me. Yeah, I honestly think they did it to add like a little bit more protection for the prosecutors after that one guy looked like he was going to charge the prosecutors. I don't know. But yeah, it bothers me too. Anyways, this is a long one. I was trying to find a good time to say this, and I was also practicing off screen. While I was muted, I was practicing. Cheshire Cat. Nailed it. See, I'm getting good at it. First try. Boom. Thank you so much, bud. I appreciate it. I
mean, for me, that's the bottom line. I mean, I'm worried about this AR-15 issue, but it's probably more of a national phenomena that we got to kind of deal with in terms of that and the registration. So I get that. But the ones that are registered to him, I'm trying to figure out why they didn't travel with you guys or with somebody down here today to get them to Ann Arbor.
Well, Your Honor, that's another thing. And Madam Prosecutor, I guess we don't know each other, but I did come here today early and I told her somebody would have dropped them off like before court. And then she had indicated to me she was going to confirm with the police department on whether they wanted to pick them up or I just have somebody come before we were even in front of you to drop them off. And that was the last we spoke.
And before court was after the morning docket started, so I have not had an opportunity.
To check.
Correct.
I mean, I had no problem. The email was sent yesterday, last night, if Ann Arbor Police Department wanted to pick up the guns. Your Honor, I will tell the court this. They will be
who? Okay.
They will be here today. I mean, they'll go straight to Ann Arbor Police Department right now. I'll call whoever family members can go pick them up and
I want the guns.
We're gonna get the guns too.
Oh, I know.
Oh.
And so I need confirmation that those guns, that Ann Arbor will take them. Well, I know they will. That's not gonna be a problem. If they show up at AAPD, they're gonna take them.
Right.
So I need those guns here before he leaves here. If I don't have the guns, he's not leaving.
We'll do that now.
Okay, let's go do that. I'm gonna pass the matter and let Ann Arbor know that they're on their way. You go call whoever you gotta call. They gotta get down here.
Got it. Thank you.
In recess. Well, be a short day. Oh, yeah, get up. Okay, bye. Thanks, Alan. Yeah.
I love the ending of that. The court's in recess, all right. It's like, oh yeah, I got to get up and leave. Oh yeah, that's how this works. That was a funny way to end it. I've got part two. I'm gonna play that, but I got a question for you. My bonus clip of the night is the Judge Middleton clip, but it's it's just meh. It's Judge Middleton, so I like Judge Middleton. So no, I added that to the end, or I could sneak peek my video for tomorrow morning. The video tomorrow morning is out of Battleground. I always want to say it's Michigan. It's Battleground Michigan, but I'm pretty sure they say Washington in the court. So is there a Battleground Washington as well? I could have been completely wrong the entire time I've been watching this court, calling it Battleground Michigan. Anyways, do you want to watch that court where there is the defendant is deaf, has an ASL interpreter, and let's just say the defendant's extremely frustrated and she signed some not court appropriate words. So you guys decide, while this second clip is playing, I will put up a poll and you guys can decide what we finish tonight on. The ASL interpreter with the defendant going off on the court, or we can finish with Judge Middleton as normally planned. But we've already hit about an hour, so we're probably going to go for about an hour and 20 tonight. So yeah, you guys pick which one. I actually got to load this separate because I made this video before part 2 came out. There was like a 40-minute recess before part 2.
Court does call the case of the people versus Ali Abu
Coder.
Coder. Abu Coder. I'm trying to put the syllable in the wrong spot. Okay, counsel, state your appearance.
Good afternoon again, Your Honor. Hassan Hamadi on behalf of Ali Abu Coder. State your name, Mr.
Ali Abu Coder.
All right,
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people.
okay, and my understanding is we don't have confirmation yet. What I will tell the court is the individual is at the Ann Arbor Police Department. I contacted the Ann Arbor Police Department to say, hey, this is the vehicle that the guns are in. That's as far as you got. Yep.
I am awaiting confirmation, but as far as I know, they have arrived at Ann Arbor Police. They're facilitating the turnover now.
Okay, so let me ask this, how many guns came down? There was in fact an AR-15.
Yes, one AR-15 and one.
Glock 19 or Glock 40, one of them.
Well,
I was told it was a Glock 19.
Well, I don't care what you're told. I guess what registered under from the prosecutor's position, I believe there's a Glock 40 that's registered under his name. And there was a 9mm, I believe.
There are two, according to Detective Jamil from Ann Arbor,
yes,
there are two weapons that are registered to the defendant. One is a Glock 40 that was registered to him March 20th of 2020. The second is a Caltech 9 model P11 that was registered to him on April 12th.
Thank you so much, Cheshire Cat. I appreciate it. Generous of you. Yeah, I wanted to make sure you had that link. Not a lot of people asked me for the actual court link, so I wanted to make sure you had it. And yeah, my mods didn't have it, so they couldn't give it to you. And then I had to figure out a smart way to send it to you because you can't drop links in YouTube unless you're a mod. And I'm not a mod for KCC, but thank you so much for the super chat. And yes, Jude Middleton, that was on purpose. That time it was on purpose. I was trying to be funny.
Of 2006.
That makes sense, Your Honor. Which is actually corroborates what my client had indicated. The 2006 weapon was forfeited to the Wayne County. He had at that time, a while back, he had a CCW case where they took the weapon and he never got that back. And then the 40, he did tell me he purchased a gun during COVID, which makes sense, 2020, which is the 40. But there is an AR-15 that is also in the vehicle with the 40. So a pistol, which is the 40, as well as the AR-15 is what's getting turned over. Which all he has. Do you have any other weapons?
No.
Okay.
But didn't you say there was another one that was registered to him?
The Caltech 9, which was registered to him in 2006.
Okay, so that's the one that you're saying was forfeited.
Correct.
Okay, so there should be a Glock and an AR-15 that are turned over.
That's correct.
Okay. All right, so that everybody doesn't have to wait for this, and then forfeited. 15 and Glock. Some specificity. So here's what we'll do is we don't have to all wait here for confirmation. Confirmation to come through. Madam Prosecutor, if there's a problem, let counsel know. And we would set something at 1 o'clock tomorrow if that happens via Zoom. So to try to get everything straight regarding that before this proceeds on next week or in a few days for a preliminary exam.
Understood.
Okay.
I would be an idiot to ask for this, but I feel like I feel like I was going to ask for this before this whole motion was filed. And I don't know if it makes sense. I already told my client, you're on home confinement in Wayne County, and then Washtenaw County put you on home confinement. I was going to ask Wayne County to take him off of home confinement, which I have not done yet, obviously. Your Honor, don't worry about it. I strike everything I said. I'm not going to ask for a bond issue right now, especially that the court has had mercy on us and kind enough to take care of us on the weapons. You have a wonderful day.
All right, and let me just say this.
That was incredibly self-aware of that attorney to do. He was pushed in a little bit because he is lucky that his client isn't in jail right now for violating that order. Even though it wasn't at his house, he was still ordered to surrender all of his firearms. And he did not do that. He should have been on top of it. Even though you're not in the house, you should still be on top of it. I mean, he's got 2 tethers on. So there are 2 different jurisdictions that are watching every move he's doing. You should be crossing your T's and dotting your I's. Don't sign the blue paper if you don't know what you're signing. See what I did there? Call back to the last case.
Sir, your attorney's a very good attorney. And he's the only one that saved you from being locked up. I need you to understand that.
Yes, sir.
Because he represented what you told him to this court, that there was no AR-15. And there happens to be one.
Yes, Your Honor.
And it's only through the eloquence of his argument that this court is showing you any grace to not lock you up tonight, just for even making that or causing that misrepresentation to be made to me.
Thank you.
Don't thank me, you thank him. It's
Your Honor, and I do apologize.
I would.
I do apologize for that. You know, we try to be as honest as human beings as possibly, but sometimes for many reasons, you know, anyway. Thank you, Your Honor.
Thank you, sir. Okay.
It helps if I click unmute. David, thank you so much for the 5 gifted memberships. I appreciate it. And welcome to the 5 new members. David, you were awesome. Thank you so much. I appreciate it. All right, who won the poll? Who won the poll? Yeah, it's okay, Sid. Oh, it's so close, though. So close. I think that's the closest I've ever had a poll. Man. All right. Maybe we just do both? You guys want to hang out for another like half hour? Be a long night. We can do both. But the ASL case is going to be released tomorrow anyways. But you know what? The ASL case won. So I got to play the ASL case. I mean, why put up a poll if you're not going to play it? Now, here we go. You guys know my rule. Know my rule. When I play a sneak peek video, I guess it's not a sneak peek because I'm actually playing the whole thing. You don't have to rewatch the video when I post it tomorrow, but please at least click on it and hit the like button. I would really appreciate it if you did that. I really would. But this one is interesting. And for those of you that don't know, and I'm not saying that I'm anywhere close to, the handicap that this defendant had, because she's fully deaf. I am half deaf. When I'm in court, I can't hear anything that's going on. So every time I visit a court, I can't hear. So I'm just sitting there, just kind of waiting for the judge to acknowledge me, and then I'll interact. But as Sly, like I'm constantly looking over him. I was like, what did he just say? What did he just say? What did she just say? Or Debbie Baker the second time. Yeah, same thing. He just because I can't hear what the judge is saying unless they're talking really loud. So it's already frustrating to me. I couldn't imagine being fully deaf in court. So going into this, I can already see how frustrated she is. And you can see it too, and how, I don't know, she's signing very loudly. Let's just say that. Okay, let's go.
Let's go to Mr. Cheney on Ms. Wrinkles, I believe.
This court had that file.
I have the file.
Right,
Okay. And do we have Ms. Connor? There's Ms. Connor.
Good morning, Your Honor. This is Luann Connor, Washington State Court Certified ASL Interpreter.
Thank you. Ms. Wrinkles, can you see Ms. Connor and her ASL sign language?
Yes, I can. I can see her.
Thank you. Can I have you sign your name and date of birth, please?
Yes, my name is Tambra M. Wrinkles, and my birthday is 1/28/84.
Ms. Wrinkles, your attorney, Mr. Cheney, is with us here in the courtroom. Go ahead, Mr. Cheney.
Your Honor, this is Jackson's case, but I'm filling in for her because she wasn't able to be here. She is asking for a set over to 712. I believe Ms. Wrinkles came in yesterday.
I'm sorry, Your Honor, I can't hear what he's saying.
Microphone was off. Thank you. This is Ms. Jackson's case. She is seeking a set over to September 12 to discuss the case with the prosecutor. I believe Ms. Wrinkles came in yesterday, so we are well within speedy trial for that set over. I understand that Ms. Wrinkles may be interested in bailing out. And it is my belief that in order to effectuate that inside the jail, she would need to talk to the jail staff or supervisor, but they are obligated to help her with interpretive services even within the jail.
And did you want to be heard? It looks like right now she's being held on bail on this case. Did you want to be heard in regards to that, Mr. Cheney?
It looks like she's got, yeah, if the court wanted.
Yeah, and this is why I'm really glad I'm playing this tonight, because I am not going to say that in my recording for tomorrow. Yeah, that wasn't. I did not choose my words well there. What I meant is you can tell she's frustrated when she's signing. That's what I meant, and I probably should have just said that and tried to, instead of trying to make it sound cute. I don't know. But why in pause? So we got Sparkle. Thank you so much, Sparkle, for the super chat. I appreciate it. Guess I got to play both. Yeah. I mean, we can play both. If you guys want to hang out that long, we can do it.
To vacate that or reduce it to no bail, that would be much appreciated.
And it looks to me like she has some pending city warrants as well, Ms. Carmi.
She does, Your Honor. She's being held on $2,200 on ours currently. She has a $500 hold for a VPD case. Actually, the remaining cases are all VPD. A separate $500, the $500 is combined with another case. Then there's a standalone $1,000 bail bond in a Vancouver theft 3 case. Our bail is set at $2,200. This is a 2021 case. There's been significant difficulty getting Ms. Wrinkles here, getting this case resolved. There is now, as of February 13, 2024, the same charge, theft 3, pending. We would ask for bail to be reduced to $1,000 in our matter, but otherwise remain. Ms. Jackson and I have already talked about this case, and it will likely be a credit for time served offer that would put us through to the next court date.
I think at this time, I am going to lower the bail. I think I'm going to lower it and be consistent with the amount that the city of Vancouver is requesting. So I will lower the bail from $2,200 to $500. Yes, it has been difficult to get Ms. Wrinkles to show up in court. I don't think releasing the bail totally accomplishes that. However, I do think that the $500 bail is more appropriate. So Ms. Wrinkles, we are going to see you on September 12th, will be your next court date at 10 a.m. You certainly can reach out to Ms. Jackson in the meantime. If you have reached resolution on this matter, we do have a court. The court is available on the 5th of September as well. Release conditions, including no contact with Walmart and intensive pretrial release, will remain in place.
Okay,
Yes.
could I say something? Could I ask the court not to be at 10 in the morning? Because the last 2 times I was supposed to show up, I did ride the bus and went out there, but the time didn't give me enough time to get out there by 10. So that was what my issue was.
Sounds good. How about we put the next hearing at 3 p.m.? Would that work for you, ma'am?
Yes, will you be able to release me so that I can show up in Battleground on the 12th at 3 o'clock? Because that way I have enough time to arrive there on the bus.
Go ahead, Mr. Cheney.
Your Honor, I am concerned about the ability to effectuate bail. We can certainly set it at 3 o'clock, but my suspicion is we'll likely be here on the 8:30 in custody docket.
So what would you like, Ms. Langberg?
So what we can do is, go ahead and set up for 10 a.m. And then if we get, the paperwork that she wanted out, we'll reset that to 3 o'clock, send the hearing notice to her and update this car.
So at this time, Ms. Wrinkles, I have lowered your bail to $500. But because we've been working to get you out to show up for court now for 3.5 years, I am going to leave that $500 bail in place. If you are still in custody on the 12th of September, you will appear that date from the jail, and we will utilize an interpreter, and that will be in the morning. If you bail out, we will then have your hearing instead at 3 p.m. So if you are out of custody, 3 p.m. will be your court time. If you are in custody, it will be in the morning.
Okay, I understand what you're saying. My next question is, how do I have the phone numbers of people who are out there that I can call? Because I don't have any cell phone. I have video phone, but I don't have numbers for anyone. So how do I contact someone on the outside to talk to someone? The new lawyer just turned me off, and so it's super frustrating. I don't have any way to contact people out there. So I understand the $500 bail and I accept that and I can afford that, but how do you actually get out to get the money to get bailed out?
Okay. So the court is asking me, is there an address that you are currently residing at, ma'am?
I have a mailing address, but I'm homeless. So I have a camp and I have a dog there and all my clothes and my personal belongings and everything are there. So if I don't go back there, then I lose all my stuff and I don't want to lose all that. So those things are really important to me.
So I understand. Is there, but you're saying in terms of the people that would be called to provide bail for you, you don't know those people's phone numbers?
That's correct. That's correct.
I don't know how we can assist.
I don't believe that's my obligation to, or my firm's obligation to chase down.
Saying
Man, I don't like this attorney. I do not like this attorney at all. Now, I understand why the defendant's frustrated. She's in a position where she needs help to just do the basic things to get out of jail. She just said, I have the $500, I can get out, but I don't have anyone's number. And the attorney speaks up, that's beyond the scope of my obligation or my firm's dude, just help your client get out of jail. If she has the money, you can do that. I don't like it. And it's this that the defendant said earlier that the defense attorney just kind of hung up on her earlier. Man.
Her obligation. I'm just thinking out loud and trying to figure out if this person does say they can afford bail, but does not know any phone numbers and does not have a interpreter resource in jail.
I do believe the jail is required to give her an interpreter resource. That's why I think she should talk to the jail supervisor if she's not getting that.
They provide a tablet for video phones, but that does not include any of your phone numbers that you need to be able to know how to contact people.
So do you have a phone with you in custody that has those numbers on it?
They have a tablet. Just one second. Just one second. The interpreter's going to do a clarification. Right.
This attorney's actually stepping in for whoever her normal attorney is. So he is not her appointed attorney. She has one. He stepped in to do a bond argument. And even in the bond argument, he said, "Oh, she's not going to be able to make that." And then her next thing she said was, "Oh, I can make that. I just have to figure out a way to be able to call someone to do it." All right, I'm going to let this one play out. I will play the Judge Middleton clip because you guys wanted it to. While I am paused, Wixom, thank you so much. You're with Sparkle. I got it. Thank you so much, Wixom. All right, this is when it's about to go down. Let's just say I'm sure the interpreter feels very uncomfortable with what's about to be what she has about to with what she is about to say to the court. All right, I'm gonna let this clip play out, and then we're gonna go to Middleton.
My cell phone, I don't have a cell phone in custody. At the time of the arrest, my phone was with my friend plugged in, so it is not in police custody.
I don't know if there's any way, ma'am, if no one has that phone, that we're going to be able to get you those numbers. I'm very sorry. All right, that concludes our hearing. Thank you. Thank you, Ms. Connor.
Wyatt Medlin, Mr. Medlin.
Your Honor, this is a setting of October 3rd. We are looking for an outright case. I know Ms. Connie's working on that, so.
So I'm stuck. That needs to just fuck you.
So Ms. Wrinkles, I don't know if you can get her attention. No.
So I don't care. Fuck you, fuck you, fuck you. I don't care. Fuck you, fuck off.
Okay. So Ms. Connor, we're going to go ahead and conclude.
It's so hard to do better with my life, and I know I'm not showing up to court. I know that. That's not true. I'm not showing up to court. All this is just shit. And then I wish I could not be deaf. I wish I was not deaf.
Sorry, ma'am. All right, Ms. Connor, thank you for joining us today.
You're welcome.
Conclude that matter.
All right. Yeah. So that was sad, and I completely understand her frustration. I completely understand it. She's getting screwed because she can't hear, and she can't use the normal devices. I really feel like that attorney needs to help her out a little bit more. When he says it's not his obligation, I disagree with that. It absolutely is. You are the person who is supposed to help her get out of jail. You don't just do a bond argument and say, "Oh, I'm not doing it anymore." You know what? I don't usually swear, especially I do when it's on Monday, Members Monday, but I don't usually swear. But that attorney can fuck right off. Like that pissed me off. It really did. Okay, Judge Middleton clip. You guys asked for it. Take deep breaths, Colin. Take deep breaths. Take deep breaths. All right, let's go.
Good morning, Mr. Roberts.
Good morning.
Thank you for joining us. Once again, you got dragged into one of these tow matters. I had him call and give you a heads up, and then before you got the subpoena. So thank you for being here. You're at your new office?
I am.
I haven't been out there to see it. I've been in your.
Hey, sorry, Wixom. I meant to bring this up before I started this clip. Thank you so much for the gifted membership, and welcome to the new member. You guys have been awesome tonight with gifted memberships. Thank you so much, guys. Everyone's awesome.
Old office. You've got a lot more space out there. How is it going out there?
Going well. A lot more
How
room.
many ac- Yeah, a lot more room. You were very much confined being in the city limits there. How much space do you have?
Now we have 15 acres, but we only using about 6.
Well, that ought to be enough room. Mr. Pontius, can you hear me?
Can you hear me, sir?
Yes, good morning.
Good morning.
All right, looks like we've got everyone that we need. I'll call the case. This is actually entitled In Re, the impoundment of a motor vehicle, a 2010 Harley Davidson motorcycle. The petitioner is Stephen Pontius, and the respondent are Rachel Britton, T.J. Baker, Jason Bingaman, and the vehicle custodian is not the sheriff's department. It became a broker's towing and storage. I excused Deputy T.J. Baker from further proceedings in this matter because he really had very little to do with this. Deputy Lieutenant T.J. Harrington is present, and Under Sheriff Jason Bingaman. Also Deputy Rachel Britton, who was here previously and testified under oath regarding the impoundment of this motorcycle. Mr. Stephen Pontius, the petitioner, is here also by Zoom. Joining us today is Mr. Kevin Roberts. He is the owner and operator of Brokers Towing, formerly of the city of Three Rivers, now just outside of Three Rivers. Mr. Roberts has testified in a number of these matters, and he has a very good knowledge of the statute, Michigan MCL 257252. Mr. Roberts, thank you for being here. I'm going to start out by swearing Deputy Britton, Mr. Roberts, and Mr. Pontius. Would you all please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yeah.
Yes, sir.
All right. We heard from Mr. Britton and Deputy Britton and Mr. Pontius about this motorcycle. Mr. Pontius had purchased it without a title, contended it was a salvage vehicle. Someone asked the Central Dispatch to send an officer to do a title search on it, and it was determined that
I believe it's January 1st. That's what I believe. I feel like Judge Middleton said that. I haven't talked to Debbie since the election, or a couple days after the election. I haven't. So this has been a couple weeks since the last time I talked to her, but I feel like it is January 1st. I wouldn't quote me on that because I think I got that from Judge Middleton, but I'm not sure where I heard that. So that's just my guess.
vehicle stolen or reported stolen out of Detroit. So the vehicle was impounded, ultimately taken to brokers. And this was all testimony taken on August 19th. I continued the matter until today because there was some conjecture or speculation as to what actually happened to the motorcycle. So I summoned Mr. Kevin Roberts to tell us what happened. So, Mr. Roberts, did you come to be in possession of this Harley Davidson motorcycle that was impounded by the sheriff's department?
We did, yes.
What can you tell us about it?
It was brought in as a impounded vehicle. It's a stolen vehicle, requested to be put on a hold inside for further processing by Detroit Police Department.
What was the date of that?
I believe it looks like that came in on July 11th. about probably 10 o'clock at night or so.
All right, what happened next?
Wait, is Judge Middleton finished after this year? Is that what you guys are saying? I thought he was the judge till 2026. I thought that's when he was retiring. Are you guys saying that he's retiring at the end of this year? Man, I hope I'm not reading. Really? Man, that just made me sad.
Oh, well, we brought it in, we made room inside and we secured the vehicle and waited patiently while this thing took up our space for the Detroit Police Department to show up, which never happened. They decided that they had no interest in doing it. It was owned by, I believe it was Liberty Mutual, and they said it was up to Liberty Mutual what they wanted to do with it. I notified the St. Joe County Sheriff's Department. I talked to Jason, and I believe TJ Baker was in the room at the same time, and asked them if they had any further interest in it. And they said no, if Detroit indicated to them that they weren't going to follow through with anything else on it.
Yeah, I just looked it up. His term doesn't end until the end of 2026. December 31st, 2026. So if he announced he's retiring early, I didn't hear that, but his term isn't over.
So we made contact with Copart, auto salvage company. They've been calling numerously to try to get the vehicle redeemed. So then they
Right,
said,
now,
pick up.
tell me who this is. Copart Auto Salvage?
Yeah, it's like an insurance auto auction. The two biggest ones we deal with are Copart, and they deal with specific insurance companies. And then there's IAA, Insurance Auto Auctions. So your wrecked vehicles, stolen recoveries, flood vehicles, anything of an insurance relation typically goes through one of them, and it's an auction, just like a used car auction for salvage.
If you know, how did Copart find out about this?
Well, as soon as the owner of the vehicle was notified that it was redeemed, which the owner was Liberty Mutual, then Liberty Mutual would contact through Copart. So my guess is Detroit Police Department notified Liberty Mutual that your vehicle's been redeemed. So then that's what started the process.
Negative. All right, well, you'll have a chance to respond, Mr. Pontius.
Oh, yes, sir.
All right, then what happened next?
They came and redeemed the vehicle. They paid our bill, picked it up, and it's gone.
So Copart did on behalf of Liberty Mutual?
Yeah, it was on August 7th. It was Scott's Towing and Salvage on behalf of Copart. So who picked it up about 1:30 in the afternoon.
What was your tow and storage bill at that point?
$3,638.80.
And the vehicle was released, and that's the last you saw of it?
That's correct.
The law requires, as you know, Mr. Roberts, there was confusion, frankly. We've discussed this. The statute was contradictory, and the question of whether a petitioner had to post a bond or not was open-ended until the case of Noel v. Ritzer, who went to the Michigan Court of Appeals and said a petitioner has to post a bond before they can have a hearing. Well, this vehicle has already been redeemed, paid for, and is gone. So I did not require Mr. Pontius to post a bond. but it would have been in the neighborhood of $3,600 before we would even have this hearing. So
I don't want to interject, but under 257, 252F, the only one that can file a petition is an owner or the secured party. So unless we have a bona fide owner, we shouldn't be here.
yes, there is certainly a compelling argument to that effect. But here we are. All right. Does anyone have any questions for Mr. Roberts? Mr. Pontius, anything you wish to ask him?
No.
Under Sheriff Bingaman,
Yay, Mia! 10 months. 10 months. I think you're the third person I've seen in double digits. Thank you so much, Mia. I appreciate it. OG member. You were there for my very first test live. I think you might be one of the few people that I actually remember or that still comes around from that. For those of you that don't know, my very first live was an accident. I just wanted to test how it worked. I clicked go live. I didn't think anyone was going to be there. I was just kind of testing how to bring up clips, how to do everything. And all of a sudden people started showing up. Mia was one of them. Mia, you were awesome. Thank you so much for hanging around. I appreciate it every time you see your face. Hopefully that's a little bit better than can I get a message? Yay. Thank you so much, Mia.
anyone else?
No,
all right. Mr. Roberts, thank you. It helped us get the full picture of what actually happened. And so now we know that. You're welcome to stay if you want to watch the rest of the proceedings. I know you're busy. I'll let you go.
Well, I may be able to help you through this.
All right.
Don't know. I kind of watched brief through the previous hearing you guys had. And the thing is all out of shape.
Yes.
So
all right, well, I'll just leave you there for now.
I'll be able to help you.
All right, I'll mute you for now and then we'll just see where we go. Oops. All right. We take a.
I still have that recording. It's just on private. Maybe for like my 25K celebration, I'll play that. I only went live for like 20 minutes just to test out how everything worked. But yeah, there were like 15 people showed up. And I didn't announce it. I didn't say I was doing it. Wait, you know what? I think I might have. I might have said it in someone's Discord. Did I? I don't know. Anyways, let's get back to the clip. Yeah, this whole case is a mess. Dude in the bottom middle essentially bought a stolen bike, didn't get a title, then he lost the bike because it was stolen, and he's trying to claim that it wasn't stolen. That's where we're at.
Lots of testimony. We've heard about the fact that this vehicle was in fact reported as stolen. We discussed the fact that with motor vehicles, a title is required. And in this case, the title was in Liberty Mutual Insurance. Mr. Pontius, is there anything else you wish the court to know?
Yes, there is.
All right, well, I'll certainly hear what you have to say. Go ahead and tell me.
Bill of sale. I have the bill of sale. I know it's not title, but it's a bill of sale. It's a receipt for the purchase of the property. Okay, and another thing, the day that we went to court last time on the 19th, I called Copart and he ran them into their whole system. And he said, we didn't come pick up that bike. He said, we don't have that bike. I also called Liberty Mutual. I called them yesterday. They don't have any record of that bike, that motorcycle. Why is this? Can anybody hear me?
I hear you. I don't have an answer to that question. Everything you just said is hearsay. if
But you say
anyone was
that's-
here from Liberty Mutual to tell us that, or Copart.
I'm under
Uh,
oath.
Yeah, but
If this
that doesn't abrogate the rules of evidence. What someone else told you is hearsay. That's why I asked Mr. Roberts to come and tell us directly what happened. Um, You have a bill of sale, and as we discussed this the last time, this is a motor vehicle. It's not a piano.
Private
It's
property.
not a piece of artwork.
It's a motor vehicle when I
You
registered.
you have a bill of sale for a stolen motorcycle.
I have a bill of sale. for
And the
property.
whole time you owned it, you never were able to obtain a title for it. In fact, the title was in Liberty Mutual. Now, I was gonna give you this, Mr. Pontius, because I got what I will refer to as ex parte communication from someone that watched the hearing. And it was put in the file and I read it before I realized what it was. So it doesn't really affect my decision, but you're entitled to know because I did read it. A viewer, his name is Martin from New Mexico, said, I am a retired.
Martin from New Mexico. His he's probably jumping up and down. He mailed in a letter explaining. Judge Middleton's about to read the letter right now, but his letter he wrote in to give his 2 cents on the case is being read in on the record right now. It's kind of hilarious. Hey, what's up, Pia? Is it Pia or Paya? Pia, Paya. I don't know, but hey.
Casualty Insurance Loss Control Services, with an emphasis on pre-loss property safety inspections. In New Mexico, we aren't in New Mexico, statutes, an insurance company is fully entitled to all physical property ownership rights upon full payment of claims regarding said physical property. I presume statutes in Michigan and other states are similar.
I am way off. Peer. Man, what nationality is that? That's awesome. Peer. All right. And Peeps, you said Eric Martin. Speaking of which, Eric Martin is in court tomorrow. Yep, you know I'll be there. Judge Slavin tomorrow. Set for 8:30, but they probably won't call him till the end of the docket because he takes forever. But yep. And it's not his jury trial. It looks like his jury trial actually got pushed back till the end of September. It's kind of hard to read the dockets because it doesn't really explain everything. But it's not a jury trial. They don't really have what it is on it yet. So I'm guessing they're waiting till tomorrow, and maybe they just set it for a jury trial, set it for a set time, and we'll find out tomorrow what actually it's going to happen. But yeah, that's the Eric Martin update. We'll find out tomorrow what's going on. Okay, let's finish this clip. It's almost over.
The most likely scenario is the insurance company transferred the vehicle to itself to preserve their rights subsequent to paying a claim proffered by the previous owner. The person who owned the motorcycle, it was stolen and they made it a claim with their insurance company and they paid for it. And when the vehicle was recovered, the insurance company had taken the title to it. And the insurance, now absent that, Mr. Pontius, in order for you to get that bike out of impound, you have had to pay, as of that date, August 7th, $3,638.80. This company paid the impound, had the vehicle taken, and presumably sold at auction.
I wasn't able to get the bike out no matter what. There was a police hold on it.
Yes, because it was stolen. So you're certainly going to have a right to appeal this, but I agree with Mr. Roberts. You don't even have standing to bring this action because you're not the titled holder of the property. I find that the police agency complied with the procedures established for the processing of abandoned vehicles under the statute 257-252A, B, and D. It is ordered that no refund of charges shall be made. The vehicle has been redeemed.
Yeah. I was never given the opportunity to redeem the vehicle. And why till that day? Why till the 7th? Because that's the day they picked it up.
Yeah.
That's the day. What about the day after when I was claiming the motorcycle as mine? Here I am, but nobody would listen to me and I couldn't get it out because there was a police hold on it.
Nobody would listen to you because you didn't have a title for it.
But I have a bill of sale. I bought the property.
I don't care. I have a bill of sale is somebody can write on the back of a napkin.
Well, I'm not going to register my vehicle with the state.
Well, so you're not the owner of it, according to the state.
Well,
So
right.
I find
I'll
that the
appeal it.
police, well, you can certainly appeal it.
I will.
The police, Deputy Britton, the sheriff, undersheriff, went the extra mile contacting Detroit directly. Mr. Roberts does what he does. He comes and answers the call, impounds the vehicle, gives notice to the title holder. The title holder came and redeemed it. And
I
you
think it's
are.
awful funny that everything that everybody's telling me, I can't verify.
What do you mean you can't verify? You can't verify that the bike is yours. You bought a bike that was stolen. What the only thing you can do is take that bill of sale and sue the person in small claims court for your $3,600 back, or however much whatever the bill of sale is. Something tells me he bought it for like $1,000. The bike's worth $3,600 and he was buying it stolen. He didn't pay $3,600 for it. Anyways, all right, I'm gonna let this video play out. A couple shout outs real quick. Wixom, thank you so much for the gifted membership. Also, Cheshire Cat, thank you so much. You just want me to say your name, man. The more times I do it, the better I'm getting at it. Thank you both, Wixom and Cheshire Cat. Thank you so much for the membership, the gifted memberships. You guys are awesome. All right, there's a minute or two left on this video. I'm gonna let it play out. We did have a really long stream tonight. While it's playing, I'm gonna see who we can potentially raid. I know Jen Hardy was on at 9. I don't know if she's still going. I may have eclipsed her time, but yeah, I'll look to see who we can raid. Thank you all for hanging out. Thank you all for the gifted memberships, the super chats, the membership milestones. You guys are awesome. Thanks again to Biggin for the awesome raid. Yeah, that's all I got. That's all I got. Yes. One more time for the sneak peek video that I'm releasing tomorrow morning. Again, you don't have to rewatch it. I think it's good. I'd rewatch it if I were you, but you don't have to. But if you don't mind, just click on it and hit the like button. And then you can go back on with your day. But I am going to be releasing that between 8 and 9 tomorrow. I just got to record my voiceover and that's it. It's already ready to go, as you just saw. And I got a little practice run in so I can make sure I don't say dumb things. Okay. You guys are awesome. Until next time, bye.
Fine. You want to cut me off? Have a good day.
Well, no, I'm not gonna cut you off, but there's nothing else to say about it. You didn't have the title. The police
I don't
did.
need the title to
follow
purchase it. If I wanted to make parts out of it.
You don't need the title. You need the title to own it. I'm not gonna argue with it anymore. I've ruled in
Do I need a
their
title to hold
behalf.
my couch?
You can appeal it and I will enter the order today. Mr. Roberts, thank you for being here. Everyone else, you're all good to go. And I'll send you a copy of that order, Mr. Pontius.
Yeah. I disagree and I don't accept it, but.
All right, well, you don't have to. Deputy Britton, you had a question?
Yeah, when this is done, can I go into a breakout room with Mr. Pontius so I can give him an update on the criminal side of this? If that's okay with you, Mr.
Yes.
Okay, thank you.
Mr. Pontius, you would like to talk to the officer?
Yes, I would. I'd like to apologize to her for, I was just trying to get some information and I just want to apologize to you for bringing you in like this.
You're okay. We can talk in the breakout session
All right.
and I'll give you an update on that side.
Yeah.
All right, just click join. Mr. Roberts, thank you for your help. Some point I'll stop out and visit your new office.
Sure.
Okay, so.
Mr. Pontius, click the button that says join the breakout room.
I was waiting for you to, did you finish giving your order?
Yes, I did.
Are we done?
Yes, we're done.